Every day in the USA, people find themselves in court.
All right, I have a proceeding supplemental for plaintiff Bernicio Acevedo, and this is against defendants Lorenzo Ralios Castro and Ashley Sherman Faudre. This is 2309 SC 1863. Give me one moment to pull this case up on my screen. You may be seated, thank you. Again, 2309 SC 1863. Do I have Mr. Is it Acevedo?
Yeah, that's me.
All right, appears in person. And I have two defendants listed. I'm guessing you're Ashley Sherman Faudre? And Lorenzo Ralios Castro is not here?
No, he's at an emergency surgery.
Okay, all right. So I'll show Miss Sherman Faudre appears, but Mr. Lorenzo Ralios Castro does not. Is there any relation? Are you married by chance to the other?
No, but that's how they put it in the paperwork when they file papers against us that we're married and we're not.
Okay. All right. I only ask because under the small claims rules, you are allowed to appear to someone to whom you're married, but you're not allowed to appear if you're not married. Only attorneys and spouses can appear for somebody else. So technically, the defendant fails to appear for today's hearing.
When I filed the paperwork on why we had this court date, because we already seen the magistrate, she said that either one of us could appear.
Let me look at what paperwork was filed. So it looks like this case started in a different court. It was transferred.
But I have no clue why. Because I think he filed a paperwork against me as soon as he received the thing from the magistrate in the mail.
Okay.
I filled it all out on a paper. You should have gotten it.
Let me take a look at what you asked for, ma'am. Okay, so just for your background, the Elkhart County courts underwent a realignment in their courts. We have 7 different courts, and up until December 31st of last year, all of the 7 judges handled a combination of civil, criminal, family, probate, etc. We got to be a big enough county that we decided it made sense to specialize. So some courts, such as Superior 6, where Judge Bonfiglio is, are going to be only family law courts from now on. And my court, Superior Court 5, is going to do only civil cases, like small claims from now on. So for that reason, there were transfers of many cases. I was shooting all of my criminal cases down to Goshen. They were flinging up civil cases to me. That's the reason for the transfer.
Right, but we've seen Bonafito, and then we went to trial with the magistrate, and now I've got a new court date.
Give me a moment to check this history. Since it wasn't in my court before, I don't have any background. All right, so I now see Magistrate Burton's order, which entered judgment for the plaintiff and against the defendants jointly and severally in the amount of $1,583.33 plus court costs. And that looks like that was done. All 3 parties appeared for the trial. It says trial came on for hearing on March 12th, 2024, and the Magistrate Burton signed the order the next day on March 13th of 2024. That was just last month.
So within like a week or 2 of us getting the paperwork back, it took like a week or 2, he came down and filed this. With you, and I have no clue why.
This probably being the verified motion and proceeding supplementary. So, ma'am, that type of motion is something that is filed and can be filed by anyone after they receive a money verdict, a judgment in their favor. Unless a defendant promptly receives the notice and goes and pays it in full, the plaintiff has the right to figure out how they're going to get paid on their judgment.
That's what he keeps doing, but I just now got a job, and I filled out a paper in there asking for a weekly amount to be paid of like $30 to $50, and it got denied.
Okay. I'm the one who's going to set it, so I don't care who did what, and I want you to do something, because I've determined in the first 5 minutes of this hearing, every time I'm about to explain something, you're interjecting something. I just want to ask you to sit back and listen to what I have to say before you tell me everything that you want to tell me, okay? Understood?
It's just upsetting, sorry.
Okay. So you went to trial. Magistrate Burton found for the plaintiff. He entered a judgment. The plaintiff now has the opportunity to collect on that judgment. He called for a standard hearing that thousands of people call for it a year. When defendants get their judgment and don't promptly write a check and pay it, they have the right to figure out how they're going to get paid. We have these hearings with a standard form, a verified motion and proceeding supplementary, which is what the plaintiff filed. It actually ordered both you and Mr. Ralios Castro to appear to talk about how this is going to get paid. Right now, I only have you. I typically start these pro sup hearings by swearing in a defendant or defendants. So I'm going to ask you to raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God.
Yeah.
Okay. You may put your hand down. What is your full legal name?
Ashley Sherman Foodray.
Okay. And you were just mentioning that you just got a job. Is that correct?
Yes.
Where are you working? And when did you start there?
Last week.
Okay. What is your hourly rate of pay if you get paid by the hour?
$12 an hour.
Okay. How many hours a week are you working?
Barely 30.
Okay. Do you anticipate working 30 hours each week for the foreseeable future?
Maybe.
Okay. That would result in a gross pay of $360 a week. Do you get paid weekly or bi-weekly?
Bi-weekly.
Okay, so that would be $720 every other week gross. Now, taking out for taxes using some standard math and rounding down for easy math, if you were bringing home $250 a week or $500 bi-weekly, I will tell you that Indiana garnishment laws allow for the plaintiff to intercept or garnish up to 1/4 of somebody's net disposable income. Now, I recognize that 1/4 of somebody who's netting $500 every other week is a pretty significant portion. That would be $125 every other week or over $250 a month. So what I try to do in my court is give a defendant the opportunity to propose some other amount that's lower than what the garnishment says, that is both acceptable to the plaintiff and something that a defendant feels they can do religiously, faithfully, without missing it. What would you propose to pay every pay period, every other week?
I said every week, $30 to $50.
Okay, I'm going to just go with 40 for easy math. $40 a week, and you want to pay it weekly as opposed to bi-weekly?
Yes.
Okay. Mr. Echevedo, any reason why $40 a week is not acceptable to the plaintiff?
I'd have a quick question. Is that only going to be her? What about Mr. Castro?
Well, I'm going to talk about him because he was ordered to be here. I want to know a little bit more about the surgery that he's having. What's going on with Mr. Ralios Castro?
He had to take his nephew to emergency surgery. His sister doesn't speak English.
Okay.
And I was the only one that lived in the apartment, and he knows that. But he thinks that taking my ex to court, he's going to get money.
Okay.
And it's not right. And we already did all this through the magistrate.
Right, and the magistrate already found that both you and your ex owe the money jointly and severally. I don't care if he lived there or not, if he signed a lease as a guarantor.
Right, and I said that...
Ma'am, don't interrupt me. I don't care if he lived there or not. Magistrate Burton found for over 30 days ago that you and your ex are liable for this judgment. You didn't appeal it within 30 days, so it's a judgment, and I'm going to enforce it.
That's fine, Your Honor, but
Thank you
I went
for your
next
permission.
door.
I appreciate that.
But I went next door when I filled out my paperwork, and she said that one of us had to appear.
She might not have known that there was an order of this court that was issued requiring both of you, ordering both of you to appear. Now, I am sure there are other ways and other people who could take a nephew for emergency surgery, but if Mr. Ralios Castro doesn't want to appear to talk about what his income and assets are, I'll ask you what they are, and maybe we can work off of that. Is he working?
No, I'm the only one working.
Okay. He's going to have to come back and tell me about why he's not working at a follow-up hearing. So as a timeout, sir, I'm going to authorize you to file what's called a motion for rule to show cause. I'm going to ask my assistant Ray to give you a motion for rule to show cause form. You are free to sign that. You can file that. It would set another hearing similar to this one, but a little different. In addition to talking about what Mr. Ralios Castro's income and assets are, it would also order him to be here to explain why he shouldn't be held in contempt of court for disobeying the order to be here today to talk about this money judgment.
Okay.
If you file that, we'll get a hearing on the calendar. If he's served personally with that, and it's a little bit different because it could end up with him being jailed, he needs to have personal notice of that. So if he's served personally for that and does not appear again, the court could sanction him. But that's for another day. I just wanted to address that since he's not here today. In the meantime, did you have any other questions that you want to ask before we talk about a payment plan for Ms. Sherman Fadre?
No, just no more questions.
All right. So, ma'am, we have a form called a payment and notification order. It does two things. It orders the payment plan that you have yourself suggested. And the second thing, it orders you to notify the court of any change in your mailing address and any change of your employment within 48 hours of that change. So if you get a new place you want your mail sent, you need to let us know within 48 hours. If you lose your job or quit your job at Johnson Industry or Johnson, where it was, you need to let the court know within 48 hours. Also, if you receive any sum of money greater than $300 through anything other than your income, such as a tax refund, a stimulus check, lottery winnings, a gift, inheritance, whatever it may be, any lump sum over $300, you are ordered to let the court know within 48 hours in writing with a copy to the plaintiff. Okay? If you don't do that, you could be held in contempt of court. For today, this form is going to indicate that you shall pay the $40 every week that you referenced. And if I were to begin it a week from this Friday, so that you'd have to pay on Friday, May 3rd, and every Friday after, is there any reason why that would not work for you?
No, I'll pay it like tomorrow or the next day.
Okay, all right. Well, I will start it on May 3rd. If you want to pay ahead, you are certainly free to do that. Just don't pay behind. If you ever default on this court-ordered payment plan without further hearing on motion of Mr. Echevedo, the court can issue a garnishment order, which would allow for that greater sum, $125
I understand.
to be garnished. Okay, so that's all the more incentive to make sure that you pay it as ordered. Ma'am, there's a form, the one closest to the pen on your table, that tells you how you can pay. You're free to take it, or you don't have to. If you remember everything, you don't need to grab that. Any questions about that order, ma'am?
No.
Okay, then my assistant Ray is going to put a form in front of you. You are welcome to read it over. It says everything that I just said. Once you sign it, you are free to go.
One question, where do I get the payment from?
So after either Ms. Sherman Padre or Mr. Alios Castro make payment to the clerk, they will turn it around and mail you a check usually within a week. So
Okay.
you might want to make sure if your address changes that you have it current so that the checks will
It's
arrive.
still the same.
Okay. And before we conclude, you have the right to ask any other questions of the defendant about assets, income, etc. If you have any questions while she's on the road, you're welcome to do that.
No, I'm good. As long as she starts paying, I'm good.
Okay. Okay, ma'am, if you don't have any other questions, you're free to go. Thank you.